Through the Legally Speaking series, we hope to bring to you views and conversations from stalwarts at the bar, on the bench, and members of the legal community. In our previous edition of Legally Speaking, we had Mr. Shiva Mandal engage in conversation with Mr. Nish Shetty. We saw a large audience actively engaging with the speakers. We've had multiple requests to make these sessions available later, and keeping with demand, we will be releasing the videos from this series soon. Today, we have with us Mr. Darius Khambata being interviewed by Mr. Adrian Winstanley. Darius, Adrian, on behalf of the MCIA community and all those joining us live, I welcome you.
Thank you.
Though both our speakers are well known in the field of arbitration and need no introduction, but it is customary for us to introduce them. I will first introduce both our speakers and then request Adrian to commence the conversation, post which participants will be allowed to ask questions that they can submit on the Zoom app. Darius. Darius Khambata is a senior counsel, an LLM from Harvard, practices before the Bombay High Court and Supreme Court of India. He has held 2 distinguished public law offices. He was the Advocate General for Maharashtra, and before that, he was Additional Solicitor General of India. On his tenure as Advocate General coming to an end in November 2014, the newly constituted state cabinet recorded, and I quote, its highest appreciation of the meritorious and distinguished service rendered by him. He has appeared in several important constitutional, corporate, and commercial matters and in significant and high-stake domestic and international commercial arbitrations. He has written several published papers, including on arbitration, and in 2013, he was conferred with the Arya Chanakya Rajya Puraskar for Law. We welcome you, Darius.
Thank you, Neeti.
Adrian Winstanley is an English solicitor with over 20 years experience in international commercial arbitration and mediation, acquired in his roles as Registrar and Director General of MCIA, and in his earlier role as a member of the Clifford Chance arbitration team, and is now an independent arbitrator, mediator, and ADR consultant. He has spoken and written extensively on international arbitration. Adrian was awarded the OBE, which is the Order of the British Empire, in June 2013 for services to international arbitration. Commercial Dispute Resolution magazine wrote the following for Adrian, and I quote, "It would be hard to argue against the proposition that Winstanley is one of the chief architects of the success of London as a center for international dispute resolution." End quote. Adrian is also a member of the MCIA Council. We are grateful to Adrian and Darius to join us today for an interesting conversation about different aspects of international arbitration. With these words, I hand over to Adrian now.
Neeti, thank you very much for your generous introduction. Darius, it's a real pleasure to be speaking to you today. And
Likewise.
I'm most grateful to colleagues for organizing this series of webinars during this global lockdown. I hope that you and our MCIA colleagues and all those participating will stay safe and well until the battle against coronavirus is won. And it's appropriate, I think, that we start on the question of coronavirus. COVID-19 is the greatest global crisis of a generation at very least. So my first questions, Darius, are, will the much talked of post-coronavirus new normal extend to a continuation of the virtual arbitration hearings that have been so rapidly and widely embraced? Or are in-person hearings irreplaceable, at least for larger and more complex arbitrations?
Thank you, Adrian. Great to be here, and hope likewise that everyone is safe and well, and stay safe and well. Well, we're here whether we like it or not. And the world has changed, Adrian, whether we like it or not. It's up to us as to whether that change is to the good or is entirely negative. And I think this calamity, in a sense, does give us a bit of an opportunity. Now, you know, in international commercial arbitration, we're very familiar with remote hearings. In fact, most smaller hearings are remote. You have the one, perhaps if you're lucky, 2 personal hearings in the lifetime of an arbitration. And most of the orders and most of the decisions are all e-decisions across emails because of the simple reason that you've got people scattered all over the world participating. And it's simply too expensive and impractical to have them congregate every time you have to decide one or the other matters. So in a sense, in the world of international commercial arbitration, we have a bit of an advantage. We've been there, done that. So to that extent, it's to the good that we will now have to have more virtual or remote hearings. That said, I entirely agree with you, Adrian. I think one cannot eliminate the physical hearing entirely. There's a great value in that. And at least for the moment, it looks like there'll be no physical hearings. But one would hope in 6 to 8 months' time, when some sanity returns to all of this, the physical hearing will be restored to its rightful place, which is just the one part of an arbitration. It should not be all dominating. It should not be all pervasive. Just that last final hearing, there's a great value in having a face-to-face contact with the tribunal, and for the tribunal to actually see the lawyers it's dealing with and to have that interaction.
That's I fully agree with what you're saying, Darius. And do you think in general that arbitrators and arbitration practitioners and institutions are adequately geared up to take this forward? I mean, people are reacting to as they go along, how best to deal with these situations, and they're being very innovative and creative in that. But do you think by and large there's going to be a transition period where all of the stakeholders have to rethink the way in which they do things, or are we pretty much there because we've been obliged to get there very quickly?
I think to a certain extent there will have to be rethinking, perhaps even reinvention. But as I said, much of this has already been done by international commercial arbitral institutions. So it's only a matter of extending what is already part of the system. There will have to be modifications, there'll have to be improvements. For example, it's usually not the case that you cross-examine or take evidence in a virtual hearing. You would usually have a physical hearing for that. So you are now talking about evolving ways of making it work in a remote hearing. It's not difficult. If it's a matter of the security of the process, there are measures you can take to ensure the witness is not being tutored. But of course that physical eye contact between counsel and a witness, which is so important, as you know, in cross-examination, is lost to some extent. On the other hand, there's one huge advantage that I see which is not available if you have a physical hearing. And this is particularly important for lawyers from India. You know, Adrian, we in India are steeped in the oral tradition. I think the pendulum perhaps has swung too far in favor of oral arguments in India, but that's another debate. But we do like an oral closing. And often one finds in the usual form of an international arbitration, when you have one tight hearing in which you have openings, you have evidence, and then perhaps a short oral closing, it's not quite enough sometimes in a matter that's fact heavy and evidence heavy. And quite obviously there's no space for having a second congregation of everyone just for an oral closing. So more often than not, the substantive part of the oral closing is in writing, as we know. But if the hearing is in any case going to be remote, then you have space for saying, well, we'll devote a week for evidence, and we will recongregate a week later, perhaps, virtually, and keep aside a day or perhaps a day or two, if necessary, for a substantive oral closing. So there are ways you can actually turn this to your advantage.
I think that's right again. And there's an interesting development this very week where 3 of the big hearing centers, IDRC in London and Maxwell Chambers in Singapore and Arbitration Place in Toronto, have formed what they call the International Arbitration Center Alliance. They're looking for others to join, other centers to join this, and I'm sure it will be of interest to MCIA. And essentially they're offering what they call a hybrid hearing. So they're saying that for argument's sake, rather than have everybody who is in an arbitration seated in London rush over to London from around the world, let's have parties who are closer to London come to London in due course, or those that can make it.
Yes.
Let's have those that are closer to Singapore, could be in Singapore, in Canada, wherever it may be, and in due course to Mumbai. And let's link up those centers. So in other words, despite the fact, of course, the centers are in competition, it's a new way of thinking. And the other thing that is coming out of this, which is quite striking, of course, it's very hard at the moment to find anything silver in the lining of this terrible cloud. But one thing's for sure, the skies are clearer. And I think that the whole environmental and green agenda also has an impact on what we're discussing now. It's a disaster for the airline industry. We understand that, travel industry and so forth. But I cannot imagine anymore, after this experience in particular, my getting on a plane to go to Washington for a 3-hour meeting and a dinner with somebody and turn around and come back again. Why would I do that? Why would one do that? So I think that from the point of view of the environment and green issues, then I think there's a real potential to exploit this in business as a whole, not simply in dispute resolution. So this, I think, may be a positive change once we emerge from this terribly dark tunnel. But let's just ask another question on before we move on from the coronavirus. Do you think that the huge economic impact of coronavirus will give rise to a surge in litigation and arbitration in the same way that we saw after the 2008-2009 global economic meltdown? Or do you think the lessons learned from that earlier crisis will see an increased demand for swifter, more cost-effective, less contentious ways of resolving disputes? I remember very well, because I was at the LCIA still after that terrible meltdown, and the institutions were doing wonderful work. I mean, we had a tremendous doubling of the cases that came in. But there was a sense also that some parties felt that they were throwing good money after bad. Everybody was chasing debts that were probably not recoverable, and they were saying, why are we going through the whole process of a full-blown arbitration taking 18 months or something of that kind? There needs to be a creative way of thinking, and on the back of that, I think, came what we see now frequently, which is the demand for swifter processes, more cost-effective processes, rather than having things drag on. So that's a slightly long-winded question, but you get the point. Is there to be a surge, do you think, on the back of it? If there is, are we ready to meet that with cost-effective and swift solutions?
Thanks, Adrian. You obviously took in a large gulp of air, with this clean, fresh air that we're all now breathing, to ask that question.
Now I need a glass of water to oil my throat.
And perhaps something stronger after I give you the answer. The answer is that I think there's going to be much less money in the system after this crisis. This is actually far worse than 2008, because 2008 was a downturn. 2020 is actually a stoppage. So there's going to be more disputes, but also a greater eagerness to learn from the lessons of the past and to have cheaper ways of resolving them. Now, at a certain level in some countries, that might work in favor of arbitration. I think in India, it certainly will. But internationally, where arbitration is actually more expensive than going to court, I think you're going to have a demand for at least two things. You're going to have many more people choosing fast-track options that institutions provide. And that's again to the good. And you're going to have a lot of arb med arb, because people are wanting to settle their disputes rather than going through a full-fledged arbitration. So I think, yes, lessons should be and probably will be learned. We'll have shorter, swifter mechanisms and arbitrations, but we'll have a lot more of them, I think.
Yes, it's one of those, I suppose that any situation, however grim it may seem on the economic front, in this case on the health front, of course, seems to fuel more work for the lawyers. It's one of those grim realities. When times are easy and times are good and everything is plain sailing, then the lawyers are less busy. When things are bad, then the lawyers are more busy. And it's not that they necessarily rub their hands at that prospect. It's just the reality of the global economy. Although for another time, we might consider whether the whole concept of globalization, with which we've become so familiar, is going to be stalled by this particular pandemic. You see, in particular, for example, President Trump now openly attacking China, accusing it of responsibility for this. And it's hard to see that at the end of this there won't be serious repercussions in terms of trade barriers and so forth. But that's perhaps for another time. I'd like to look now, if I may, Darius, at the question of India as an international arbitration hub. India had, for decades, been regarded by the international business and legal communities as a risky venue, as a seat and for international arbitration. As a consequence, both of the jurisprudence in the field and going back into history, Bhatia and Venture Global, Balco, Reliance Industries, and so forth. And importantly, of a seemingly extreme reluctance to cast off ad hocism in favor of administered institutional arbitration. Speaking of the establishment of the Arbitration Council of India, ACI, before the passage of the Arbitration and Conciliation Amendment Act of 2019, Lord Goldsmith, who everybody is familiar with, I think the former UK Attorney General, expressed the view that the proposed changes to Indian arbitration law would set back India's progress in the arbitration arena by a generation, saying that the idea that a government-appointed body should regulate arbitration and arbitrators is anathema to the idea of free and autonomous arbitration. And Lord Goldsmith and others have also raised concerns that the new act effectively disqualifies foreign registered lawyers from acting as arbitrators in India, seated arbitrations. So in your view, has the 2019 Act helped or hindered India in its efforts to establish itself as a viable international arbitration hub? I suppose the bigger question really is, generally, is India making the sort of progress in this way that you would wish to see? Is there cause to be optimistic about India's place in this field?
Well, let me start very generally, Adrian, with my answer to that. I've been saying for years now that India is a classic case of lost victories. There is really no reason why India shouldn't take its rightful place at the table of international arbitration. We have about 150 years of common law, Indian-made common law, which is recorded in the form of judgments of courts. Along with that comes a huge body of very skillful and trained and competent commercial lawyers who are adept not only in commercial law, but in matters of evidence and trial. You have, by and large, we've had a very independent and innovative judiciary. And that's a very important facet of this whole game from whichever way you look at it. That's something we need to preserve. And of course, you have now increasingly better infrastructure, you have cheap skilled labor. So you have all the factors that would make for a good arbitration venue. Apart from the fact that English has always been the lingua franca of dispute resolution in India. There's no reason why India has lagged behind, but it has, let's be honest. And I think the successive governments have been trying their best to remedy this situation by first having an act such as the 96 Act, which is UNCITRAL model law really, and then amending it dramatically in 2015, and rather less so in 2019. The 2019 amendments really are in two parts. There are the small bits and pieces that have already got done. And there are some amendments, or other, shall I call them proposed amendments, which are yet not notified by the government, and they do not come into force as law unless they're notified. Now, amongst those are the two things that you mentioned, the Arbitration Council of India and the qualifications for arbitrators. And let me go one by one. Arbitration Council of India, is it really necessary? In India, we love regulators, we love councils, we love commissions. So grant us that. And at least on the statute book, it seems like a policy-making body. The question I really have is, it's very easy with a short amendment to convert what appears to be a policy-making body into a regulatory one. And that's the danger. And I'm not sure you really need a policy-making council when you can have the government itself set its policy by way of law. the Arbitration Council comes as with a full-fledged CEO and a board and all the other paraphernalia that you would normally associate with an institution. So is it an attempt to find some kind of super arbitral institution for India, given the fact that you mentioned that there, for some reason, institutionalized arbitration is anathema to most Indian participants and lawyers. Most of it is ad hoc. There are better ways, of course, to encourage institutional arbitration than this. And I think, on balance, I'm not in favor of the Arbitration Council of India. I don't think you need councils to start grading institutions. The market will grade them. After all, arbitration is ultimately party autonomy, isn't it? If the parties choose an institution, well, then that's the best one for them. They don't need grading. So I think that's also unnecessary. Accreditation of arbitrators, that's the next point you raised. Do you really need accreditation? Do you really need to be told, well, you can go to this person because he's accredited, but you can't go to that person, though you may have utmost faith and confidence in him because he's not accredited. And then you impose qualifications on arbitrators. And apart from the fact that, with utmost respect, I think the 8th schedule is not very well drafted. It's actually, it doesn't make sense because you require, effectively it's slanted in favor of qualified professionals, whether they be architects or accountants, which again is the antithesis of your being able to choose your arbitrator. And it seems to think that an advocate of 10 years standing is good enough. And there are advocates and advocates. Someone of 9 years standing may be even better, but the 8th schedule says you can't appoint him. And then again, that advocate has to have a knowledge of all sorts of laws. I'm not sure any of us have that sort of knowledge. It's just not Indian constitutional law. It's all sorts of laws. It's contract, labor, the law of torts, customary laws. It's the works. Very few Indian lawyers could hand on heart say that they have a good working knowledge or they're conversant with all these branches of laws. Apart from the fact, as you rightly put it, it immediately and in one fell swoop eliminates any foreign lawyer or any foreign individual from acting as arbitrator, because he's not going to have this knowledge or qualification. It's sometimes said, well, this provision doesn't apply to foreign arbitrations because it's in Part 1. But we must remember that Part 1 applies also to international commercial arbitration seated in India. And I thought that the endeavor has been to encourage those rather than discourage them. Now, in one fell swoop, if you notify the qualifications, you're not going to have any non-Indian able to act as an arbitrator in India. That would be a very negative feature. That would be a backward step. And I think, and I hope I'm right, I think the government has realized it because they faced a lot of criticism, starting with Lord Goldsmith. And all of us spoke publicly about this. And they might have pulled back because they still haven't notified the section.
Darius, it's without being impertinent as an outsider, I've been so frustrated over the years. You know that the efforts that I personally and the LCI put into the establishment of LCI India, and a passionate belief on my part and of colleagues at that time that the potential of India was simply not being realized in this field. And very little has changed, and all that effort that went into trying to, as you know, when I left the LCIA, quite quickly they decided that they would not continue to invest. And I'm obviously extremely pleased that MCIA, as Niti remarked at the time, just moving one letter up the alphabet, LCIA became MCIA, was established. But at the moment, I'm not sure that I can see that if the ACI is to accredit institutions, including MCIA, that will necessarily encourage the sort of, let's say, confidence in Indian institutional arbitration that is so desperately needed to realize that potential, or whether further regulations, as you say, and the establishment of another regulatory body that looks like a full-blown institution of some kind, simply to the outside world says, well, here's another roadblock on the path to India becoming recognized as an international hub. Because frankly, Darius, you know, people, it isn't a problem. I mean, we're talking about the difficulties of resuming physical hearings, for argument's sake. But there isn't any problem for somebody arbitrating their India-related disputes in Singapore, as they do very frequently. But it seems such a waste of the potential of the resources of India that this should be happening. So I suppose, again, as an outsider, my hope is that we may see this, let's say, this move rescinded in due course. If you're saying to me that is in prospect, I think that would be quite a relief if you think it may be reconsidered.
It might be, but I mean, this is pure conjecture on my part. Obviously, I have no information on this, but the fact that it hasn't yet been notified is a good sign.
Let me turn, if I may, quickly to the question of the enforcement of foreign arbitral awards and public policy in India. And I raise this because the Supreme Court of India, as you very well know, of course, rendered two seemingly contradictory judgments very recently in Vijay Kariya against Prismian Kavi, if I pronounce that right, and just a couple of months later in Nafed against Alimenta, respectively. In the Kariya case, the court enforced a foreign arbitral award very narrowly in interpreting public policy provisions. In Nafed, they appear to have done exactly the opposite. Just, if I may, just a couple of quotes for the benefit of the participants. In Kariya, the Supreme Court held, and I quote, "The important point to be considered is that the foreign award must be read as a whole, fairly and without nitpicking. If read as a whole, the said award has addressed the basic issues raised by the parties and has in substance decided the claims and counterclaims of the parties, enforcement must follow." So enforcement of a foreign award could not be denied merely because it was in contravention of Indian law. In Nafed, on the other hand, the court appears to have delved deeply into the merits of the case, which one would argue were for the arbitral tribunal alone, concluding that enforcement should be refused as being against the fundamental public policy of India on the basis that the award accepted the supply of goods contrary to the export policy of India. Now, at first reading, to see those two decisions, one hot on the heel of the other, with apparently entirely different interpretations and certainly application of weight to the decisions of the court, one is confused. Can you unconfuse us, Darius?
I can't promise to succeed in doing that, Adrian, but let me try. Let me have a shot. And let me start by saying, overarching submission, I think the judgment in Nafed was unfortunate. I also think it's wrong as a matter of law, but I'll come to that a little later. In India, India was one of the first countries to ratify the New York Convention. We took an active part in its drafting, and in 1961, we had our Foreign Awards Recognition and Enforcement Act. Section 7, 2B of which had the public policy ground as one of the rare grounds on which a foreign award would not be enforced. And for the next 30 years or so, we actually had a fairly good record of enforcing foreign awards. And the law regarding that was all summarized and put together in one masterful judgment in the Renusagar case in 1994, where you had your 2 or 3 basic principles, and they were that the fundamental policy of law was a fundamental policy of Indian law, no doubt, but it was what we call the narrow view of public policy, not the wider view. There are 2 views within the Indian domestic law system. Secondly, it also said, and this is very important, that the merits of an award could never be impeached. Thirdly, it said that there was a vast difference between a contravention of law or a breach of law on the one hand, and a violation of the fundamental policy of law or the public policy of India on the other. And the first was not really automatically the second. In that case, there was a breach of the provisions of the Foreign Exchange Regulation Act, FERA. And the court said, well, it might be a violation, but it certainly doesn't constitute a breach of the public policy of Indian law. And then that judgment defined the 3 pins on which the law has really ever since proceeded in India, which is that the public policy of India consists of three things: fundamental policy of Indian law, justice or morality, and the interests of India. Let's get the third one out of the way immediately. The interests of India now no longer is part of the policy of Indian law. The 2015 amendments to the 96 Act make that very clear. This judgment was given under the 1961 Act. In 96, we adopted the UNCITRAL model and the New York Convention almost verbatim. In fact, the convention is a schedule to the Act. Section 48, which is the enforcing Article 5 of the New York Convention, really sets out the New York Convention grounds. And thereafter, most judgments followed the Renu-Sagar principles even under the 96 Act, because the provisions were really the same. And we have a whole series of judgments, which, including Sri Lal Mahal, and of course, you've mentioned the latest one, which is Vijay Karya's case. Vijay Karya and Renu-Sagar were three-judge bench decisions of the Supreme Court. As you know, our Supreme Court doesn't sit en banc, it sits in benches, and judgments of a larger bench will overrule judgments of a smaller-sized bench, even sub silentio. But both Renu-Sagar and most of the judgments after that were either 2 or 3 judges, as is Vijay Karya. Now, here comes suddenly Alimenta, just a few weeks ago, 2 weeks ago, I think, which has actually been long in the pipeline. It's a 1989 foreign award, and I just wonder why it has taken so long to come up. And it was a challenge under the Foreign Awards Act of 1961. So that's damage limitation point number 1. It's not under the 96 Act at all, certainly not under the 96 Act as amended in 2015. So it can be completely distinguished on that ground, and I don't expect that you have other such matters, or too many of them at least, in the pipeline. But the second point is that I'm not sure how it fits in. The judgment in Nafed Alimenta was also 3 judges. So the judgment in Renu-Sagar completely bound this bench, being a coordinate bench. They couldn't have taken a different view of the law. So they actually recited the law as laid down in Renu-Sagar, and much of the judgment is a recounting of law. And there's just one paragraph where they put it all together by saying, well, what they did in the first part of the judgment was to delve headlong into the merits of the award. They said, look at clause 14, it's a force majeure clause. This is not a frustration case at all under 56. It's a section 32 case. Contract stands terminated. There were export control orders. And being a canalizing agency, NAFED could never have exported this quantity without the express permission of the government of India. Indeed, the government rejected their application. Accepting all of that, it would still amount to a breach of law, a breach of the export control order. But then in one sentence, without any reasoning, the court says, hence, there is a breach of the public policy of India. And they ignore the law in Renu-Sagar, which says every breach of law is not a breach of public policy. There is no reasoning in this judgment which shows how this breach of law constitutes a breach of public policy. And I think that's the Achilles heel. So I'm not sure, even under the 61 Act, that this law, this judgment can be relied upon to say anything other than what Renu-Sagar has said. And Renu-Sagar is fairly clear. So I would hope the effect of this is very, very limited.
Thank you very much, Darius. So an aberration. I'm very conscious of the time, and I think we need to turn, although we had other topics we might have discussed, to some of the questions that have been coming in, which I see now on my screen, which I hope is not blocking anybody. Let me take them not one at a time. Let me pick some out. This is a question, Darius. What role can be played by young lawyers in the process of effective dispute resolution in the future? I rather like that question because
it's a good question.
For many, many years, there's been a view that there's this elite, there's this body of very experienced arbitrators and lawyers who somehow monopolize arbitration. I've never subscribed to that. And I'll turn it over to you in a moment, but my initial reaction is that the young lawyers have an extremely important role to play in improving and maintaining the process of arbitration, the quality of arbitration. And I would encourage all young lawyers to consider this branch of the law. And going back a little to the question of accreditation, many years ago, Jan Paulsen remarked that the making of a good arbitrator is a process of gradual accretion. And I like that notion. You start young as a bag carrier, you maybe do some advocacy, and in due course you find yourself in a position where parties are confident to appoint you. But in truth, some of the finest young arbitrators around these days are below or in their early 40s. So the short answer, I think, is what can young lawyers do? They can do a lot. They need to embrace arbitration. And insofar as India is concerned, I think they need to pursue those kind of avenues we've been discussing. And that is helping India in due course to become a recognized hub without all the frailties that currently beset it. But Darius, what is your view of the role of young lawyers in arbitration?
I think, Adrian, you've pretty much spelled it out. We know this as the older lawyers of arbitration or indeed of litigation, that you're frankly only as good or as elite as your last case. One slip and the whole world knows about it. We operate in a goldfish bowl. So I think there's huge opportunity for younger lawyers to come up now and strike out. And I think one of the ways they can do it is by, especially in India, is by voluntarily adopting the best international practices. Even when you participate in a domestic arbitration, don't get schizophrenic and treat it differently. Approach it as you would an international arbitration. By that, I think most of you know what I mean. It means emphasis on the written word, make sure your written submissions are sharp, focused, to the point, fairly detailed, of course. Make sure you don't ramble, make sure your pleadings are focused, make sure you meet the point against you rather than trying to duck it or obfuscate it. And I think if you do all of this and be timely in your approach at all stages, if you do all of this, I think you can teach all of us a lesson or two. And I think by process of osmosis, you can actually be the game changer. So I think there's in fact huge potential for younger lawyers today in India.
Darius, that's very helpful, and we're very much on the same page, you and I. And again, conscious of time and seeing an awful lot of questions, let me pick a couple of others. This is a question for you, Darius, and it goes as follows. Does India's current stance on foreign direct investment and investment arbitration bode well or ill for its efforts to attract foreign investment at this critical time in the global economy? Obviously, we're thinking here, first of all, about going right back to white industries and then the model BIT of India. And on the FDI front, of course, a year ago, the opening up of investment pretty much automatically to countries bordering India. And suddenly, a few months ago, a complete reversal of that, for fears, presumably, particularly in respect of China, that there would be some sort of aggressive takeover of Indian companies in the present economic crisis. So how do you feel India is placed at this important time as far as investment is concerned, and then confidence in resolving disputes arising from that investment?
It's an excellent and topical question, and there's sort of several responses to this. The overarching response is that ultimately it does have to be a matter of the economic policy of the government. And we can only suggest and recommend, but ultimately the call is theirs. I would think that a foreign investor is usually very concerned about protecting his investment. He wants recourse to a good, quick justice delivery system, and you've got to give that to him, otherwise he's not going to bring in money. It's as simple as that. The 2003 model BIT was therefore a capital importing model. It had all the usual clauses that allowed or invited the entry of capital. 2015, the new model, which is really a knee-jerk reaction to white industries, is not, it knocks out most of the clauses, particularly the notorious most favored nation clause, which white industries use to some advantage. White industries, and that's the topic of a whole lecture in itself, shouldn't be a ghost that continues to haunt us. There are two views on that award, and one view is that the tribunal there reached out into the India-Kuwait BIT to pick out the most favored nation clause, not the most favored nation, they actually picked out the best assurance of claims clause from there, which was not present in the Australia-India BIT. And they got it into the Australia BIT via the most favored nation clause. Now, whether you can do that or not is a matter of where the jury is still out. You can make your model BIT leaner, you can make it more specific, but I don't think it has to pendulum to the other extreme of discouraging foreign investment. That's one. But two, and this is a very important point, India has never been a party to ICSID. So every BIT award is an award under the rules of the institution chosen, and it has to be enforced in India as a foreign award. Now, some things happened in the last year or two, which needs to be addressed. There are two single-judge decisions of the Delhi High Court, which have held that BIT awards, being an investor state, would not qualify as commercial disputes under the New York Convention. And as you know, India has added a caveat to its ratification and accession to the New York Convention, which is to say it's only in respect of commercial disputes. Now, of course, this was said in the context of an application for an anti-arbitration injunction, which was then not granted against the BIT arbitration. But if that principle is extrapolated and applied to the enforcement of the award, then you might have a major problem, because BIT awards could be resisted in India on the ground that they are not enforceable under our Arbitration Act under Section 48, because they're not commercial in nature. And then that would leave a foreign investor nowhere, because he'd have to file a suit, which is impossible. So I think this needs to be looked at, and I think statutorily we need to make an amendment fairly quickly to clarify that the word commercial will be all-encompassing. In fact, the Supreme Court years ago, again in '94 in the Boeing case, had said that the term commercial must be given a very wide meaning. And any practice of international trade or anything that's become common in international trade must be accepted as commercial. And Adrian, you would agree with me that bilateral investment treaty arbitrations have become very common in international trade. So there's no reason why they shouldn't be treated as commercial. But that's an area we need to look at.
Absolutely. Darius, they say that time flies when you're enjoying yourself, and I'm afraid to say that we're within a minute or two of having to conclude here. Let me throw in one final question, which we might just answer quite quickly so that we can wrap it up in good time. And it is this: is it time to mandatorily institutionalize arbitrations in India? So there's a nice loaded question to.
That's a nice loaded question. Well, I'm going to answer with one of my favorite quotations from a U.S. Federal Circuit Court decision in Ahmad Barawati's case, which described party autonomy, which is the linchpin of arbitration, as being so wide that parties could choose any procedure to resolve their disputes, even trial by combat, or more doubtfully, a decision by a panel of three monkeys. And that's the heart of arbitration, party autonomy. The moment you start imposing things on that, such as institutionalized arbitration, you're undermining, in a manner of speaking, party autonomy. So I don't think it should be mandatory, but there are many ways in which it could be encouraged, both in the statute as well as infrastructurally. I mean, look at the MCIA. What an excellent setup it's got in Bombay. I did an arbitration there recently. If we had more centers like that, more people would want to go to institutional arbitration when they saw it work as well as the MCIA work. So I think it's a matter, again, of the marketplace, not mandatory.
It's absolutely right. And of course, your illustration of MCIA shows perfectly that institutions could administer at various levels of involvement, if you like. They can provide hearing facilities and catering facilities and court reporting facilities without necessarily their rules being applied. So right. Very light touch, all right the way through to a fully administered arbitration. And again, coming back to what may be the new normal, I think we have to look at what institutions are doing and what their offering is, running the whole range from light touch right the way through to full administration.
That's right.
And I think offering everything, and they certainly do. Now, I think, Darius, unless I'm mistaken, our time is up, but perhaps our hosts will step in at this time and tell us whether that is the case. I see.
Thank you, Mr. Khambata. Thank you, Mr. Winstanley, for joining us today on the 4th edition of Legally Speaking. We got an interesting perspective on arbitration, BITs, of course, the coronavirus, and what the new normal would look like post this. Some of the more interesting ones that I found, I have to say, Mr. Khambata, is the 3 monkeys and the combat and the combat example that you gave. I've heard it before, but it never gets old.
And you need someone like Adrian on your side if you want to win.
I think we could probably take a class in jousting post this to maintain both. But thank you so much for that. I'd like to thank our audience for joining and engaging with us in conversation with Mr. Naveen Raju, General Counsel at Mahindra & Mahindra. Please do join us. I know both of you, Mr. Khambata, Mr. Winstanley, are extremely busy despite the COVID-19 outbreak, and I'd like to thank you on behalf and all those joining us for sparing your time.
May I just thank all of you, Adrian, Madhukeshwar, and Neeti, and all the participants for an excellent session. I truly enjoyed it. Thank you so much.
I would absolutely echo that. It's been a great pleasure talking to you all, and it's very encouraging to see these exchanges taking place in a very positive way, despite the clouds that hang over us. So thank you very much to everybody. It's been thoroughly enjoyable.
Thank you.